Hey, this is Hannah Hill. I'm the Executive Director of the National Foundation for Gun Rights, and I'm here with our Chief Legal Counsel, Barry Arrington. And we wanted to come to you today to give you an update from the Supreme Court in our lawsuit challenging Illinois' semi-auto ban and magazine ban. As you know, we had appealed this case to the Supreme Court. We had asked the court to step in and strike down that gun ban once and for all. And today, unfortunately, they said not yet. That's not a no. It's not on the issue itself. But they said this is not the right vehicle for it, and we want to let y'all finish the lower court process before we step in. So, Barry, could you talk us through what happened this morning and kind of what that means and why it's not as discouraging as it might appear at first glance?
Sure, Hannah, thank you. So I think that the thing to do at this point is to step back and take a broad look at what's going on in context. And so what has happened here? So we filed this case in 2022, right after Bruin came out, August of 22. And we've been fighting ever since. And what happened was in the winter last year, we got this ruling from the Northern District of Illinois that denied our motion for preliminary injunction against the Naperville and Illinois statutes. We took that up to the Seventh Circuit Court of Appeals, and the Seventh Circuit affirmed the denial of our motion for preliminary injunction earlier this year. Actually, it was late last year, late 2023. And then in February, we filed our petition for writ of certiorari in the Supreme Court. It's been pending since February. And then today, the Supreme Court says no. And I think the key word is not yet. You said not yet. They didn't say no, no how, leave us alone. This is not something that we want to hear. They just said not yet. And I think it's important to keep in mind that the interlocutory nature of this appeal, this petition for writ of certiorari, is very important, I believe, in the court's reasoning. As a matter of fact, Justice Thomas more than hints at the fact that the reason that the court turned us down is we are interlocutory. So what does that mean? It means that in the district court, we never went to trial. We never got a judgment. We never got summary judgment or a trial. We asked for a preliminary injunction and said, while we're litigating this case, we want you to enter an order saying, stop this law. Yeah. And then we can litigate. And the court refused to do that. When a district court turns down a motion for preliminary injunction, you have a right to appeal that in the middle of the case. And that's called an interlocutory appeal. And we appealed it in the middle of the case, lost the Seventh Circuit, and the Supreme Court says, go back down, litigate it to completion, and then we'll see you on the way back up. And that's what basically Justice Thomas was saying in his decision.
Now, did he give us any indicator while he was at it of how they're going to rule when it finally does come back?
Sure. And that's a good question. So Justice Alito would have granted certiorari in the cases, and Justice Alito did not have a separate dissenting opinion. But Justice Thomas did have a separate statement that he appended to the court's decision. And there's some very important provisions in that. We know where Justice Thomas is, and almost certainly Justice Alito, and almost certainly Justice Kavanaugh are going to be on this, and we need to pick up two more justices. We think that we have those other justices in terms of the so-called assault weapon ban. We use the word assault weapon in scare quotes because everybody knows assault weapons are simply commonly available semi-automatic rifles that everybody owns. I mean, millions, tens of millions of these are out there. And so what did Justice Thomas say? In his statement, Justice Thomas said, the AR-15 is the most popular semi-automatic rifle in America and is therefore undeniably in common use today. What does in common use mean, and why is that important? Because under Heller, the court said that if a weapon is in common use by citizens for lawful purposes, it cannot be banned. What's more important is that wasn't Justice Thomas speaking alone. He was quoting Justice Kavanaugh from a case when he was on the D.C. Circuit, the Heller 2 decision, where Justice Kavanaugh recognized as early as 2011, 13 years ago, Justice Kavanaugh said, AR-15s are in common use. We can't ban them. His colleagues on the D.C. Circuit did not agree. And as we know, they interest balanced the decisions there. Bruen took that tool away from them. And now we're here back in the Supreme Court. And Thomas is saying, look what Justice Kavanaugh said 13 years ago. We've known it for a long time. We need to do something about it.
And the interesting thing about that is that's two Supreme Court justices who have said that, but Justice Sotomayor recently said something very similar in another case just recently, didn't she?
And Justice Thomas quotes Justice Sotomayor, perhaps the most liberal justice on the Supreme Court. And he says that Sotomayor said this about AR-15s. Semi-automatic rifles, such as the AR-15, are commonly available. Almost the same thing as in common use. Everybody admits that AR-15s are in common use. And since Bruen, the anti-gun judges and lawyers had been pulling their hair out, trying to figure out a way around the obvious implication of Heller. And Justice Thomas takes the Seventh Circuit to task for this. He says, quote, according to the Seventh Circuit, the rifle selected by millions of Americans for self-defense and other lawful purposes does not even fall within the scope of arms protected by the Second Amendment. Justice Thomas described this as absurd. That's not my word. It's not NAGR's word. That is a sitting member of the United States Supreme Court says that the Seventh Circuit's decision saying that the most popular rifle in America is not even an arm is absurd.
And that's a really, really huge statement from them, because what we saw from the Seventh Circuit in that ruling, in the first place, it wasn't a good faith application of Bruen. There was nothing good faith about it. They twisted it. And didn't Justice Thomas point that out too, that basically what you did is you distorted the Bruen analysis, and there's nothing of text or history in your analysis and what you ended up with. That's a very harsh analysis of the Seventh Circuit's ruling.
It is very harsh, but deservedly so. Everyone knows that a good faith application of Heller results in an easy decision that AR-15s are protected by the Second Amendment. It's not a difficult situation. It's not a gray case. It's not a borderline case. It is in the very middle of Heller that the most popular rifle in America is in common use and therefore cannot be banned. So pro-gun judges know that. The NAGR knows that. Pro-gun lawyers know that. The people know that. I'm here to tell you that even the anti-gun lawyers and the anti-gun judges know that. And so what the difference is not that they don't know that Heller mandates finding that AR-15s are protected by the Second Amendment. The difference is they don't care what Heller mandates, and they figure out ways around it. And the Seventh Circuit's decision in Beavis versus Naperville, the case that Justice Thomas was referring to, is a classic example of this. You look at a good faith reading of Heller, AR-15s are in common use, got to be protected by the Second Amendment. What are we going to do as anti-gun judges? Well, we'll just say that they're not even guns, are not even firearms that are protected by the Second Amendment. Who knew that the most popular rifle is not even an arm?
What's the most ridiculous thing I think I've ever seen in this line of work? So you've been litigating this all across the country in a lot of our cases and doing an outstanding job doing that. But the interesting thing is that we've gotten so many different excuses and loopholes and arguments they've been inventing in their effort to get around the plain holdings of Heller and Bruen. I think the Seventh Circuit's ruling that AR-15s aren't even guns to start with, I think that might take the cake.
I think it might take the cake. We've had other courts say, well, they're firearms, but they're dangerous, and therefore they're not protected by the Second Amendment. Well, wait a minute. All firearms are dangerous. And if you could just say, well, that's dangerous, we're not going to let it be protected by the Second Amendment, you've just given yourself a license to ban everything, which, of course, Heller wouldn't allow you to do. And so, again, the Second Amendment says what it says, and the Heller says what it says, and its application is very clear. Everybody knows that if you apply it in good faith, AR-15s are banned. And you had some lower court judges, particularly Judge Benitez out of California, apply it in a proper way, although he got shut down immediately by the Ninth Circuit. And that case is still pending, Duncan and Miller. So let's just kind of wrap this up in our discussion with Bevis by giving you some hope. Justice Thomas says that the reason that the court is not ready to hear this case is not because it's not good on its merits. It's good on its merits. The reason is the Supreme Court is reluctant to hear cases in the middle of them on an interlocutory basis. And this is what he says at the end of his opinion. It's very important. If you're discouraged, listen to this. In my view, Illinois' ban is highly suspect because it broadly prohibits common semiotic firearms used for lawful purposes. It is difficult to see how the Seventh Circuit could have concluded that the most widely owned semi-automatic rifles are not arms protected by the Second Amendment. These petitions arise from preliminary injunctions, and the Seventh Circuit stressed that its merit analysis was merely a preliminary look at the subject. But if the Seventh Circuit ultimately allows Illinois to ban America's most common civilian rifle, we can and should review the decision once the cases reach a final judgment. The court must not permit the Seventh Circuit to relegate the Second Amendment to second-class status. That's the bottom line here. Bevis is not saying no, it's saying not yet. And Justice Thomas is saying is when we're ready, we need to hammer the Seventh Circuit if they continue with their shenanigans.
And we're prepared to give them every opportunity to do that. And I know to our members watching out there, especially if you live in the state of Illinois, today's result was discouraging. And I know that. We were disappointed to see it ourselves. But like Barry said, this was an uphill battle. The Supreme Court rarely takes a case on an interlocutory basis. Now, we were hopeful they would make an exception to that in this case because the Seventh Circuit ruling was so outrageous. And they didn't. They've applied their normal process to this. So we're just going to go back to the lower court. We're going to keep trying. But this isn't going to be the final word. And when we bring it back, we have every confidence that the Supreme Court is going to take it and they're going to rule the right way. Our strategy following Bruin was to sue everywhere, to sue over all gun bans, and to bring them a variety of vehicles, a variety of cases from all over the country, to give them every opportunity to give us that nationwide injunction. And it's not just our group doing it. We have assault weapons bans headed to the Supreme Court from a number of different locations. So we have the cases out of the Ninth Circuit that are currently waiting for the Ninth Circuit three-judge panel to rule, Miller and Duncan, like you mentioned just now. We also have Bianchi over in the Fourth Circuit, also waiting for a ruling. But for the ones that we ourselves have filed, we have two cases, a pair of cases, a magazine ban case and an assault weapons ban case right here in the state of Colorado that is actually on the merits. It is going through the summary judgment process. And as soon as we get a ruling on that, if it's a negative ruling, we'll appeal that to the 10th Circuit. So we're coming at the Supreme Court, Lord willing and the creek don't rise, within the next year. And this time we're going to bring them the kind of vehicle they like to take.
So I'm from Texas, and I'm reminded of the famous coach of the Houston Oilers, Bum Phillips. And he said of a similar situation. Well, let me back up. Early in the Bevis case, we asked the court to step in on an emergency basis. They said no. We knocked on the door. We knocked on the door again last fall, asked them after the Seventh Circuit decided, please help us on an emergency basis. They said no. And then after the Seventh Circuit decision, we went to the petition for certiorari route. We knocked on the door again. We pounded on the door this time and said, let us in. And they said, no, not yet. Why does that remind me of Bum Phillips? Well, the Houston Oilers had gotten to the AFC Championship a couple of times in a row. They lost big time the first time. They lost by a narrow margin the second time. Bum Phillips was looking forward to the following year. He said, we knocked on the door the first time. We pounded on the door the second time. The next time, we're going to kick the door in. Now, I'm not suggesting that we could kick the door into the Supreme Court, but I am saying that we're never giving up, and we're going to pound on that door until it finally swings open. And when it ultimately does, and it will, we anticipate victory.
That's right. And, we just saw an example of this earlier when the Supreme Court struck down the ATF's bump stock ban. That was not the first case challenging the ATF's bump stock ban to get appealed to the Supreme Court. They said no several times before they finally said yes. So typically speaking, in politics, as with the courts, it takes several tries before you get the traction that you're looking for, whether you're trying to get a Supreme Court ruling or whether you're trying to knock out an entrenched anti-gun incumbent. Our entire team, our members, are in this for the long haul, and we are going to outlast both the gun grabbers and the Supreme Court's procedural reticence. And we will secure that ruling, Lord willing, that knocks down assault weapons ban nationwide. But only if we keep fighting. And that is where you come in, because we need your help in this fight. This is a long, drawn-out war. This is not a single battle. We're sending Barry all over the country, and he's taking on single-handedly team after team of the top anti-gun legal minds in the United States. Some of them are from big law firms. Others are the anti-gun groups like Brady and Moms Demand Action and Bloomberg. They're the Bloomberg lawyers themselves that are stepping in and representing some of these governments that are insisting on banning guns and trampling on the Second Amendment rights of their constituents. If you want to help us continue in the fight so that we can secure that nationwide precedent striking down assault weapons bans and magazine bans nationwide, please click that link in the comments below to make a generous donation to our legal war chest. We're in this for the long haul, and we're asking you to stand with us so that we can see this fight to victory. Thank you very much.